This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So a judge has had to make a decision as to whether to sanction an attorney who wagged his butt at a fellow attorney or opposing counsel during I think it was deposition or settlement discussions. Let's take a look at the motion requesting the sanctions. This is coming from one of the attorneys or from one of the parties, and then we'll look at the judge's decision. They're relatively short, so I thought you would enjoy a fun short story here. This is Alcare White versus Chevron, the chemical company, and this is plaintiff Alcare White's motion for sanctions. This is plaintiff's first request to sanction defendant or its attorney for abuses. Defendant's attorney, Dennis Duffy, hereinafter referred to as Mr. Duffy, has embarked on a campaign of abusive and intolerable conduct that began with profanity-laced conversation. Where have we seen that before? With Christopher Hook and Todd Bank, I think. Todd Bank wasn't profanity-laced. He was just disrespectful to the judge and got thrown out, just to be clear there. It was Christopher Hook that went on a profanity-laced tirade, which escalated to discriminatory slurs and culminated into an explicit rhetoric against plaintiff's attorney, specifically Attorney Kennard. Therefore, plaintiff seeks an ex parte order disqualifying Mr. Duffy as plaintiff's counsel, restraining him from communicating or approaching plaintiffs or its attorneys, and awarding sanctions, or monetary sanctions, to plaintiff. This case involves a simple employment dispute over plaintiff's employment with defendant. Nevertheless, during the course of an August 2019 mediation, Mr. Duffy began to make abusive and threatening comments to plaintiff's counsel. Mr. Duffy made remarks and gestures during mediation that were unprofessional and disrespectful to plaintiff's counsel. Abusive language and gestures included, but not limited to, Mr. Duffy shaking his behind in front of plaintiff's counsel. So that's sanctionable conduct, according to this attorney, shaking his behind. Mr. Duffy asking plaintiff's counsel, "Do you want to have relations with me?" Mr. Duffy making inappropriate remarks regarding plaintiff counsel's hairstyle. "Do you want to, have relations with me? You have a ponytail haircut. I figured you'd want to." None of Mr. Duffy's conduct was triggered by anything that plaintiff's counsel did or said. All of plaintiff's counsel's communications with Mr. Duffy were polite and professional. The judge is going to disagree with that in a moment. Keep that in mind. As a result of Mr. Duffy's abusive language, plaintiff's counsel questions his professionalism and does not want any more instances in the future. Plaintiff's counsel is not convinced that Mr. Duffy can restrain himself in future communications based on his vulgar language. Mr. Duffy's actions go beyond the pale of anything that should be tolerated anywhere, let alone in a legal proceeding. So no disrespectful butt wagging anywhere, according to this attorney. Depositions are being scheduled for the week of March 2nd, 2020, and Mr. Duffy cannot be permitted to be in physical proximity with plaintiff's witnesses or counsel. Therefore, plaintiff has no choice but to seek ex parte relief. The worst thing about this whole unfortunate series of abusive statements to the plaintiff's attorneys is not just the thousands of dollars of attorney's time and deposition costs. It is that Mr. Duffy has proven that he is part of the minority of lawyers that the Texas Supreme Court is referring to when it states that it is committed to eliminating a practice by minority of lawyers of abusive tactics which have surfaced in many parts of our country. We believe such tactics are a disservice to our citizens, harmful to our clients, and demeaning to our profession. Also demeaning to our profession is forgetting to use your close quotes. Federal courts have inherent powers to manage their own proceedings and to control the conduct of those who appear before them. By invoking the inherent power to punish bad faith conduct which abuses the judicial process, a court must exercise discretion in fashioning an appropriate sanction. District judges have an arsenal of sanctions they can impose for unethical behavior. These sanctions include monetary sanctions, contempt, and the disqualification of counsel. In Gasatron of Arizona versus Union Oil, by the way, whoever came up with the plaintiff's company's name, Gasatron, You got my heart. I love you. I love you. That's awesome. This court recognized that a district court has the primary responsibility for controlling the conduct of the attorneys who practice before it, stating, whenever an allegation is made that an attorney has violated his moral and ethical responsibilities, an important question of professional ethics is raised. It is the duty of the district court to examine the charge, since it is that court which is authorized to supervise the conduct of the members of its bar. The courts, as well as the bar, have a responsibility to maintain public confidence in the legal profession. This means that a court may disqualify an attorney for not only acting improperly, but also for failing to avoid the appearance of impropriety. In this case, plaintiff's attorney has raised the claim of unethical conduct. The district court abdicated its duty to examine the charge of unethical behavior and impose the necessary sanctions. Mr. Duffy's conduct has gone well beyond the unethical and improper standard. It is shocking, blatantly discriminatory, and disrespectful. He cannot continue to be an attorney in this case, and the court should disqualify him. Because of the repeated and egregious nature of the violations, we request this court exercise its inherent authority to oppose monetary sanctions or disqualification of counsel. Plaintiff has incurred $7,000 in attorney's fees in bringing this motion and trying to coordinate a deposition in this case. Therefore, plaintiff requests that the court order Mr. Duffy to pay this amount to plaintiffs in sanctions. $7,000 for a 6-page motion to disqualify and apparently a messed up deposition. I can understand you got to come back to the deposition, but $7,000? I don't know. Maybe if somebody was flying in from out of state, but then again, travel costs aren't supposed to be recoupable under the fee shifting provisions of the Copyright Act. This was not copyright. I get it. And you know, maybe the travel costs can be shifted in this case, but I disagree. They conclude, litigation is tough enough when the attorneys are working together. It is tougher when the attorneys are not. Litigation becomes almost impossible when one of the attorneys decides to make disrespectful and abusive comments towards the other attorney. For years, federal and state courts have recognized the need to encourage attorneys to work together. The Texas Supreme Court went so far that almost 20 years ago it promulgated the Texas Lawyers' Creed. However, even the Lawyers' Creed recognizes that it is up to the court to punish the attorneys that violate the rules in order to encourage them to work together, be ethical and professional. The conduct by Mr. Duffy is a direct abuse of the judicial process because it undermines attorneys' abilities to work together. This court should not allow Mr. Duffy's conduct to go unpunished because his conduct goes well beyond the unethical and improper standard required by the court. Mr. Duffy cannot continue to be an attorney in this case. The court should disqualify him, and at the very least, he should be ordered to pay the costs in dealing with the unethical conduct. So then the court finally deals with it. That was filed on the 11th of February, and then finally last week on the 4th of May, we get this order. One of the sentences a judge does not imagine, much less welcome, writing includes the words butt shaking in describing a lawyer's alleged actions at a mediation. Sadly, those words fit here. Yes, among the things lawyers think, one of the frequently thoughts of lawyers is, I went to law school for this. And yeah, so did I imagine that I would be reading a judge's opinion where I, a lawyer, am reporting on a judge's opinion who's deciding a motion that was filed by a plaintiff, and we all had to use the words butt shaking or butt wagging attorney? No, I did not imagine that when I went to law school. In February 2020, White sought sanctions against Chevron and the lawyer then representing it in the case, Dennis Duffy, for making obscene and threatening comments and gestures at White's lawyer at the mediation months earlier. White asked this court to disqualify Duffy from working on the case, restrain him from communicating with White or her attorneys, and award White monetary sanctions. Chevron disputes White's allegations and argues that, among other things, White's motion is moot because Chevron had Duffy withdraw from the case shortly after the sanctions motion was filed. When a case or controversy is no longer live for adjudication, there's no live claim, then it can be said to be moot. There's other ways that it could be, other than moot, it could be maybe premature and not ripe for adjudication. In this case, it was being adjudicated, so it was ripe for adjudication, and then Duffy was withdrawn from the case, forcefully or otherwise, and so that should moot the issue, according to the defense attorneys. White replied, the court received sealed declarations from Duffy, White's counsel, Attorney Kennard, Attorney Wycliffe, the mediator, who ran the meeting where the incident took place. So sealed means we don't get to see it. We don't get to see what Duffy and Chevron's defense was. After careful review of the motion, the response, the reply, the declarations, and the law, the court denies the request for sanctions. Bet you didn't see that one coming. The declarations show significant disagreements about what occurred. While Duffy's behavior was clearly outside professional bounds, neither counsel was a role model of professional conduct. Proper objectives of Rule 11 sanctions are to deter. So these sanctions were brought under Rule 11, which is Federal Rule of Civil Procedure 11, which basically says that attorneys are responsible for what they do and file. Deterrence, punishment, and compensation are the objectives of Rule 11. The court should use the least severe sanction that is adequate to fulfill this purpose. The principle of restraint applies when a court exercises its inherent power to sanction. Because of their very potency, inherent powers must be exercised with restraint and discretion. No further or formal sanction is necessary at this point. Duffy has had to withdraw. Before he did so, he received national press coverage when the sanctions motion went viral. Duffy's professional reputation and the closely related ability to attract new business will no doubt suffer, as they should. White claims that she incurred $10,000 in attorney's fees to bring the sanctions motion and coordinate a deposition, starting at $7,000 in fees and allegedly an additional $3,000 after filing a 5-page reply and a 5-page declaration. I've charged a couple $1,000s for 5 to 10 pages of heavily researched motion, but $10,000 for this motion seems pretty high to me. Maybe a little too high. This motion is short and straightforward, says the court, and neither it nor the added deposition coordination justify the large amount of money she seeks, even as a penalty. While monetary sanctions are appropriate under Rule 11, the basic principle governing the choice of sanctions is that the least severe sanction, adequate to serve the purpose, should be imposed. The court's conclusion does not require a detailed inquiry to resolve the many factual disputes about what happened at the mediation, or who is primarily or entirely to blame. White's motion is denied. And that was Judge Lee Rosenthal, Chief United States District Judge for the District of, is it Texas? Southern District of Texas. So that is May 4th. So yeah, who knew? You could get away. I know he didn't get away. He definitely got lots of attention for his behavior. And yes, if that behavior had continued, if there was no testimony about other inappropriate behavior by the plaintiff's side, then the judge may have found some minor sanction against Duffy. Maybe just the monetary sanction would have been enough, but the fact that he was removed from the case and got national attention, and then, this sanctions motion, the judge thinks that that's enough, apparently. So what do you think of that? Would you have punished the butt-wagging attorney more, or is it more like, okay, it's a contentious mediation / deposition or whatever. It's a contentious meeting, so occasionally people will make little snide comments or little side remarks or something. No, I don't endorse sexism or discrimination. So if it was, a man saying these things to a woman, it seems kind of not just disrespectful, but aimed at the opposing party's gender. Because I don't know if you would wag your butt at a male attorney unless you were, I don't know. I never found
a lawyer dog.
Unless you were a lawyer dog. There you go. I never found myself in any situation where I needed to misbehave to another attorney. I could always use my words. I always felt like if you have to resort to name calling or butt wagging or other disrespectful gestures, then you've lost already, because you were supposed to be smart enough to use your words. You're a lawyer. You're supposed to be smart enough to use your words, and you couldn't use your words. Come on, use your words. Like we tell people with speech language disorders, use your words. So that is our show, everyone. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is our legal education and legal news channel, Lawful Masses. Support us on patreon.com/ljfrench and sponsors.com/law if you are able. It really helps our channel out and makes it possible to make these videos at all in the first place. Thank you very much to our $50 plus supporters in the month of May. I love how long this list is. Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary, Chaney, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. And the $5 plus supporters are scrolling on the LED matrix panel next to me. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. I love you all. Stay safe, stay healthy. We're going to get out of this whole thing together safely. Bye.